In less than 3 months, a vital national security tool that our intelligence community relies on very heavily is set to expire without congressional action. That tool is Section 702. 702 makes up an estimated 60% of President's daily briefing. Our government has used this tool to combat hacking and drug threats from foreign countries like China. In recent years, 702 has also put a stop to terror plots to harm Americans at home and abroad, and empowers us to take the fight overseas. As cyber threats to our critical infrastructure become more dangerous, 702 remains a valuable tool to stop these attacks before they happen. At the outset, I want to be clear about two compatible truths. First, FISA Section 702 is an essential national security and intelligence tool used to keep Americans safe. Second, constant congressional oversight and vigilance is also essential to ensure that this authority is exercised responsibly. We tried during the last authorization to ensure that the executive branch is held properly accountable, but more accountability is demanded. Our intelligence community uses Section 702 every day to protect Americans. That use is squarely in line with the government's primary responsibility to defend the American people. I've also expressed concerns about FISA's reach more broadly. I know many of us in Congress have worked hard to strike a legislative balance. Again, I say today there's still more work to be done. The Department of Justice, starting under President Biden, despite the clear language of Congress's last reauthorization, hasn't meaningfully allowed us and our staffs into the foreign intelligence surveillance courts, despite statutory mandate to do just that. So I'm astonished that the Trump administration has continued this misguided Biden-era policy. Senator Durbin and I wrote to Attorney General Bondi concerning the department's so-called procedures drafted by former Assistant Attorney General Matt Olson. We've yet to receive a meaningful response. The department can't restrict Congress from exercising our statutory oversight authority over FISA process, a process which Congress itself established in 1978. As a result, any reauthorization should demand that these procedures be revoked and that Congress, as the Article I branch, shall be able to exercise oversight authority without obstacle. Other reforms from the last reauthorization have been very successful. The querying of United States persons, while already rare, has significantly decreased, with over 100% compliance following the implementation of the most recent safeguards. Further, the more recent errors that we've seen by the FBI have been overwhelmingly clerical of that nature and not ones of bad faith. In short, Congress's reforms in 702 are making a difference. So once again, I say, however, the government's record with FISA more broadly is far from perfect. By now, we're all familiar with the FISA abuses against former Trump campaign advisor Carter Page. A few details are worth clarifying here. First, the abuses against Page happened under Title I of FISA, not 702. Second, whenever we talk about FISA and Section 02, we hear a lot about warrants. When the FBI surveilled Page, the agent obtained several warrants. Now, because of my oversight work and agency reviews, we know that these warrants were invalid and didn't follow proper procedures. Because the law as it stands doesn't provide a clear remedy, the D.C. Circuit dismissed Page's lawsuit against the government. Right now, folks improperly surveilled under FISA are without recourse. United States citizens shouldn't be subject to invalid warrants to begin with, and when they are subject to those invalid warrants, there ought to be some kind of remedy. We also ought to give Congress a role in the amicus appointment process. Right now, the Foreign Intelligence Surveillance Courts pick their own amicus. The roster of current amicus contains some people with deeply concerning partisan ties. Amica in these courts are supposed to be a check and balance in the proceedings. As such, they need to be nonpartisan. Moreover, whistleblowers from the intelligence community shouldn't be limited to providing protected disclosures to just intelligence committees. Whether whistleblowers want to disclose classified or unclassified information, they should have the ability to speak to other congressional committees. For example, this Judiciary Committee has broad jurisdictional reach into the intelligence community, and for many years I've worked with the intelligence community whistleblowers. Making whistleblower laws even more clear is a priority. I look forward to hearing from the experts joining us today on the necessity of 702 program, as well as areas where Congress should improve transparency and oversight without frustrating the importance of FISA's purpose, which is obviously to protect the American people. Senator Durbin.
Thanks, Mr. Chairman, for holding this hearing. In less than 3 months, 702 will expire. As a committee with jurisdiction over FISA, we have a responsibility to conduct oversight and to craft solutions that protect security and the constitutional rights of Americans. Given this responsibility, I am disappointed that we do not have any witness from the Trump administration testifying today. Members of this committee should be allowed to publicly question executive branch officials regarding their use of this sweeping authority, especially for warrantless surveillance of Americans. That's why when I served as chairman of this same committee, I convened a hearing with senior officials from the Biden administration so that they could be interrogated publicly and the public could hear their answers. The failure of the Trump administration to appear before this committee on important issues is a troubling pattern that must come to an end. For months, I've been calling on Secretary Noem to answer for the lawless and inhumane reign of terror her agency has unleashed on America. Secretary Noem had such a busy schedule that she was unable to come before this committee in the last calendar year. But now, she said she might find time in her schedule to join us in a mere 5 weeks. What's going to happen in Minneapolis in the next 5 weeks? When you look at the past 5, it's a legitimate question. With the Trump administration challenging our constitutional rights and the sunset of Section 702 just 3 months away, a hearing with government officials to address the use of surveillance is imperative. Section 702 grew out of a secret, warrantless surveillance program under the Bush administration. When this illegal program was exposed, Congress responded by authorizing a new authority known as Section 702. It allows the government to collect communications of foreigners located abroad without a warrant or court order for the purpose of conducting collecting foreign intelligence. There is no doubt that Section 702 is valuable. However, for years, the government has used it as a domestic spying tool to collect millions, maybe billions of Americans' private communications. And it's in searching these vast troves of these communications, reading our text messages and emails, and listening to our phone calls, all without a warrant required by the Fourth Amendment. Section 702 has been abused to spy on business and religious leaders, political parties, members of Congress, campaign donors, journalists, and political protesters of all stripes. In passing the Reform Intelligence and Securing America Act in April 2024, Congress codified modest measures to reduce these abuses. But RESA also weakened other safeguards and greatly expanded the scope of 702. It is my view, when 702 was authorized in 2008, and it remains my view now, that this section does not contain sufficient safeguards to protect the privacy and civil liberties of Americans. That is why, since the first reauthorization of FISA in 2012, I've worked on a bipartisan basis with Senator Lee, and we continue to work together to require a warrant for the search of any American communications. I urge my colleagues to join our effort. I look forward to working with the chairman to ensure that Congress does not fail the American people.
Would you like to introduce your person?
Thank you. Chairman has asked me to introduce the minority witness, and I'm sorry I have to leave after I do that. But it's my pleasure to introduce the minority witness, Liza Goiten. Liza, I hope I pronounced your name correctly. Is that close? Okay. Ms. Goiten is Senior Director of the Brennan Center for Justice, Liberty, and National Security. She seeks to advance effective national security policies respecting constitutional values and the rule of law, nationally recognized expert on presidential emergency powers and government surveillance and secrecy. Testified before this committee before. She served as counsel to this committee's Constitution Subcommittee and a trial attorney in the Justice Department. Graduate of Yale Law School and a clerk in the U.S. Court of Appeals for the Ninth Circuit. Welcome back.
Thank you, Senator Durbin, and welcome, Professor Goiten. I'd like to introduce Mr. Stewart Baker. Mr. Baker has extensive experience in government and the private sector, including as a law clerk to U.S. Supreme Court Justice John Paul Stevens. Mr. Baker also served as general counsel to the National Security Agency from 1992 to 94, and later as first Assistant Secretary for Policy at the Department of Homeland Security. Mr. Baker testified before the September 11th Commission on Intelligence and Law Enforcement Issues. His expertise in this area makes him particularly qualified to testify here today. And then Professor Adam Klein is a subject matter expert on counterterrorism, intelligence, and government surveillance. He currently serves as the director of the Robert Strauss Center for International Security and Law at the University of Texas. Mr. Klein previously served as chairman of the United States Privacy and Civil Liberties Oversight Board, where he conducted oversight of the intelligence community, including Section 702. Mr. Klein served as a law clerk to U.S. Supreme Court Justice Scalia and Judge Brent Kavanaugh when Kavanaugh was still on the D.C. Circuit. His legal and policy expertise are a nice asset to this discussion. Before you testify, I would like to make a comment that would follow up on the administration not being here to testify. Congress is an Article I branch of government. This essential program is set to expire in just a few months, and it's our job to reauthorize it. Today, we're hearing from experts with diverse views and experience, including government experience directly relevant to the program. For my part, I'm offering legislation and holding this hearing. Congress set the reauthorization clock the last time at passed in 2024, and we need to meet our own timeline. If the administration would like to brief us in an open or closed setting, I'll help work to set it up. In the meantime, the Senate Judiciary Committee needs to move ahead. We'll start with Baker and then Goiten and then Klein. Go in that order, please.
Thank you, Mr. Chairman, and members of the committee. I especially want to thank my wife and neighbors who helped me dig out to get here today. But I frankly would not have missed it no matter how hard it was to get here. I have a lot of history on this issue going back to the 1990s. I was present when the wall first made its appearance between law enforcement and intelligence. And it was eerily familiar to those of us who were participating in this debate, because the argument was, well, FISAs are easy to get, and it'll become a backdoor to doing law enforcement work on, and we shouldn't allow law enforcement use of FISA materials. And that led to a wall between law enforcement and intelligence that was designed to appease those critics, even though there hadn't been any obvious abuses. That wall got higher and higher, and the enforcement measures got tougher and tougher until in the summer of 2001, the FISA court actually imposed career-ending sanctions on an FBI agent who had stepped over the line and had impinged on the wall. That made an enormous difference in how people handled intelligence relating to terrorism. And when the intelligence community found that there were al-Qaeda operatives in the United States, presumably getting ready to carry out an attack, as we know they were, there was a plea to say we need to be able to use the law enforcement task force that the FBI has set up for the Cole bombing to try to find these people. They had 3 weeks to find them. This was in August that they got this intelligence, and they were not allowed to tell the law enforcement side of the FBI, which was really 98% of the FBI, that this had happened. These guys were in the phone book in San Diego. They could have been found in 3 weeks. We never found them until they flew their plane into the Pentagon and the Twin Towers. I never want to live through that kind of a mistake again. And yet it feels as though we are walking down the same road today. We are demanding ever more from the FBI in 702 queries and imposing ever harsher sanctions on FBI agents who set a foot wrong. We're going to make 702 toxic. It has gone from 2.9 million queries, which was certainly excessive, to 5,500. And the IG for the Justice Department has said there's a lot of reason to believe that the legitimate queries are being deterred. This is not a good situation with a tool like this. And so if I can just suggest two things that I would urge on this committee. First, a lot of these demands for ever higher, ever tougher standards for queries comes from the fact that every couple of years now, everybody gets a free shot and gets to threaten the program if their amendments are not adopted. We've had renewals in under 2 Republican presidents, 2 Democratic presidents, with Democratic and Republican majorities in Congress. I think it's time to say, let's stop putting a sunset on 702. It is only putting our most valuable security tool up for grabs every couple of years, and then praying that there is enough bipartisan spirit in the Congress to do what needs to be done. And, you don't have to be a political genius to realize that bipartisan spirit is a whole lot harder to find now than it was 5 years ago, 10 years ago, 20 years ago. Why would we say we're going to count on that bipartisan spirit showing up again and again to keep this program alive? It's time to make it permanent, and I would urge you to do so.
Chairman Grassley, Ranking Member Durbin, and members of the committee, thank you for this opportunity to testify. Congress passed Section 702 in 2008 to enhance the government's ability to conduct surveillance of foreign terrorists. Today, according to the government, it's used to combat a range of threats posed by malign foreign actors, including cyber attacks, espionage, and fentanyl trafficking. Of course, if that's all Section 702 were used for, we wouldn't be here today. The reason the authority is so controversial is that it's become a rich source of warrantless access to Americans' communications. So how did this happen? Under Section 702, the government can target any foreigner overseas for foreign intelligence purposes and collect all of their communications without an individualized court order. This surveillance inevitably sweeps in Americans' communications in large amounts because Americans communicate with foreigners. And because the foreign target need not be suspected of any wrongdoing, these communications can include entirely innocent conversations between Americans and their friends, colleagues, and family members overseas, a point emphasized by the Privacy and Civil Liberties Board in its 2023 report. Now, if the government's intent were to spy on these Americans, it would have to get a probable cause order, either a criminal warrant in a criminal investigation or a FISA Title I order in a foreign intelligence investigation. The government gets around this requirement by certifying to the FISA court that it is not using Section 702 to access the communications of particular known Americans. And yet, as soon as the data is in their hands, all of the agencies that receive Section 702 data routinely conduct warrantless electronic searches for the communications of particular known Americans. This is a bait and switch that drives a massive hole through the Fourth Amendment and FISA. In 2023, the last year for which we might have complete information, the FBI conducted 57,000 of these backdoor searches. Congress and the FISA court have attempted to place some limits on this practice, but the FBI has engaged in persistent and widespread violations of these limits, according to the FISA court. These violations have included searches for the communications of members of Congress, protesters from across the political spectrum, 19,000 donors to a single congressional campaign, and multiple U.S. government officials, journalists, and political commentators. And while the violations have at times been pervasive, the national security value of these backdoor searches, according to the Privacy and Civil Liberties Oversight Board, is scant at best. In April of 2024, Congress passed the Reforming Intelligence and Securing America Act, which attempted to rein in the FBI's backdoor searches, primarily by bolstering internal oversight and reporting requirements. We don't know the impact of these reforms, however, because the FBI failed to track all of its U.S. person queries as required by law. Specifically, the Justice Department discovered in August of 2024 that the FBI was using a tool to search for the communications of specific individuals, including U.S. persons, from within subsets of Section 702 data. The FBI inexplicably did not consider these to be queries, and so it didn't follow any of the procedures required by law, such as obtaining attorney approval or providing written justifications for U.S. person queries. The Justice Department told the FISA court that it lacked the information to determine whether these queries complied with legal standards. As a result, we have no idea how many queries the FBI conducted in 2024. The number that appears in the annual statistical report is 5,518. That's the number of known queries, the queries the FBI actually counted. The total number of queries remains unknown. And for the same reason, we do not know the FBI's compliance rate in 2024. And at this point, we have no information about 2025. This is important information, and Congress should have it before reauthorizing Section 702. But let me be clear. Even if there were only 5,000 warrantless searches for Americans' emails, phone calls, and text messages in 2024, that is 5,000 too many. Warrantless access to Americans' private communications is an invitation to governmental overreach and abuse under any administration. Congress must now do what it should have done years ago, require the government to get a warrant or a FISA Title I order before accessing Americans' communications obtained under Section 702. Thank you, and I look forward to your questions.
Chairman Grassley, Ranking Member Durbin, and members of the committee, thank you for inviting me to testify today. For almost 20 years, Section 702 has helped our government protect the American people. It has prevented terrorist bombings in the United States. It has helped stop hackers from paralyzing our infrastructure and stealing our data. It has tracked foreign spies and exposed violations of human rights. Intelligence leaders have called it essential, invaluable, and indispensable. Jargon aside, the basic principle is simple. When data from our foreign intelligence targets passes through the United States, we can collect it to protect our nation. Our allies do the same thing in their countries. So do our adversaries, but with none of the safeguards that exist in our system. It bears repeating. Section 702 can never be used to target Americans. It can only be used to target non-U.S. persons who are located outside the United States. As far as I am aware, there has never been a case of intentionally targeting an American under 702. There have been unintentional mistakes, especially around FBI queries of stored 702 data. And there have been intentional abuses of other parts of FISA, most notably the case of President Trump's former campaign advisor, Carter Page. Page was targeted under a different part of FISA, Title I, which is not a part of this upcoming sunset. Just 2 years ago, in the Reforming Intelligence and Securing America Act, Congress enacted dozens of reforms to prevent that from happening again. Those changes are working. The Department of Justice Inspector General recently found that the FBI has implemented all of the statutory changes. As a result, non-compliant queries have fallen substantially, and most of those that remain are typos, not genuine errors. That said, there is one area in which the 2024 law does not seem to be fully working, and that is enabling congressional leaders and their designees to attend FISA court proceedings. In my view, this is an important step for transparency and for oversight. I'd be happy to discuss that further during Q&A. Lastly, Congress should not require a judicial order for the FBI to search its own database of information from 702. A warrant is not constitutionally required for an agency to check its own files. The one district court decision holding otherwise rests on flawed reasoning, which I do not believe would be adopted by the Supreme Court. And requiring a court order as a matter of policy would make it harder to prevent terrorist attacks. Before 9/11, the government had enough information about the future hijackers to arrest them and to stop the plot. What a different world we would be living in today. But that information didn't flow to the people who could have acted on it. Imagine that today an FBI agent is checking out a tip that a person inside the United States is expressing support for ISIS and may be contemplating violence. If the government had already collected messages between that person and an ISIS terrorist overseas, we would want the agent to know that right away. But how would the agent know the information is there without checking the database? The 9/11 Commission told us that good counterterrorism means better using the information we already have. They said, connect the dots. The Webster Commission, which investigated the Fort Hood attacks, said it again, check the databases. I hope we will not have reason to learn that lesson a third time. Thank you, and I look forward to your questions.
For your testimony, I'm going to start with Professor Klein. Critics of Section 702 contend that the query of 702 information that has already been lawfully collected should be treated as a separate Fourth Amendment event. Please explain what it means to quote-unquote query 702 information and whether or not that's legally sound interpretation.
Thank you for the question, Senator. I want to say at the outset that we all very much respect the Constitution. I'm a law professor. The Constitution is number one. We care about Fourth Amendment rights, and I would not support anything that I thought violated the Constitution. The issue here is that this is a database created, owned, and maintained by the government from information that has already been lawfully collected. Just like a filing cabinet in an FBI field office, We don't require a warrant for an FBI agent to go look at information the FBI already has in its files and flip through to try to solve a case. That's a prudent investigative step, and in fact, it's less invasive than going out to get a new warrant to conduct new surveillance on a person and collect data the government doesn't already have. The argument, and this is what the reasoning the district court relied on in the Hasba Drami case, is that if the government seizes, for example, a hard drive or a phone or a package under another search warrant or other lawful process, and then breaks into that additional sealed container, that's a separate Fourth Amendment event. That makes sense in those contexts because those things are effects under the Fourth Amendment, effects with an E, a piece of personal property that is seized that the government is breaking into for investigative purposes. That's a separate investigative step. A government database is not an effect belonging to any of the people whose information may be recorded in that database. The government structures the database, the government architects the database, the government makes the entries and controls the entries in the database. Only the government can delete and access the database. It is not comparable to a personal effect that the government is then conducting a subsequent search on.
Professor Klein, I've raised concerns with the Department of Justice improperly limiting access to FISA court proceedings for nearly a year, despite a clear mandate from the last reauthorization to allow certain members and staff to attend, quote, unquote, any proceeding. Can you please tell us why congressional oversight of these proceedings is important and whether or not you believe the Department of Justice procedures limiting congressional access comply with the law's intent?
Thank you, Senator. Yes, Congress constitutes tribunals inferior to the Supreme Court. Congress is the Article I branch. Congress created the FISA court, controls its processes, and could get rid of it if it chose to do so. It is very important that Congress be able to form its own impression, a detailed, thorough impression of how well the court is working. Members of Congress have the right to access classified information. Many of your staff members are cleared as well. So in my view, there should be a fairly seamless procedure for members of Congress and their staff to go and see FISA court proceedings and form their own judgments.
Mr. Baker, for much of your career, you've evaluated the failures that led to 9/11, and ongoing debate centers around, quote unquote, the word wall between law enforcement and intelligence agencies. Many argue this wall was a big part of why the government missed 9/11 attacks before it was too late. Please talk about the necessity of information sharing between the intelligence community and law enforcement and the dangers of having a wall between.
Yes, and I've talked about that in the opening remarks as well. It's just a tragedy that in an effort to answer objections from law professors and civil liberties groups that there might be some kind of backdoor access, this wall was created to reassure them. It didn't reassure them. They kept asking for more. And that the government was afraid because of the politics to fight when the FISA court said, we're going to make that part of our FISA orders. And then we're going to punish FBI agents who deviate from our interpretation of the wall. The Justice Department was afraid even to appeal that order because of the political implications of that until after 9/11. The result of that was that the information that should have gone to the Cole Bombing Task Force never got to them. They never used their enormous capabilities to find these people. There are tragic emails between people arguing about whether they could bring in the FBI in which they say, someone's going to die. Why are we protecting al-Qaeda this way? Never happened. The civil liberties concerns won out, and the fear of losing their careers prevented the FBI agents from having those discussions with somebody who actually could find the attackers before they attacked.
Senator Durbin.
Thank you. Mr. Baker, you've said in your opening testimony how frustrated you are, I guess is the word I'll use, with this infrequent inquiry by Congress as to what the hell is going on with Section 702. 2 years, 6 years, we can't make up our mind up here. But the fact of the matter is, this issue is timely not just because of this section, but also because of the current American awareness of the Fourth Amendment to the Constitution. And it makes a difference, as you well know. Excuse me just a second. We're talking about situations in Chicago and Minneapolis where warrantless searches lead to helicopters landing on the roof of an apartment building and people crashing down the front doors of homes without a warrant. It appears that Americans don't care for that any more than they did at the time of the British controlling this country. It appears that people want to know, by what right are you doing this to me? And that is a legitimate question. When it comes to questions of privacy, it certainly is a concern, if not greater. Ms. Goiten, I'm trying to figure out the numbers here based on what we've heard in the testimony. The intelligence community and the FBI have touted reforms they say have dramatically reduced the number of warrantless U.S. person searches. For example, the number of such FBI searches has reportedly fallen from nearly 3 million in 2021 to about 5,500 in 2024. Is that what you understand?
Well, as I said before, we actually don't know the number for 2024. It fell to maybe 57,000 in 2023. We don't know how long the FBI was using this particular tool, so the data may be incomplete for 2023 as well. Also, we know that around 50% of the drop can be attributed to a change in the way the government counted queries, which happened for the year of 2022.
They reported to us that fewer than 2% of these searches turn up any results.
Yeah.
By my count, that would mean requiring the FBI to get a court order just over 100 times a year, far fewer than the number of court orders that they already obtain every year under the FISA authorities. Is that correct?
Most of in fact, all of the reform proposals that are under serious consideration don't kick in until after a search has been run and a communication has been identified. So, in fact, the warrant would only be required in those cases, which is 2%. So, yes, if in fact there were 5,000 queries in 2024, that would be a little over 100 warrant applications.
100 warrant applications. That seems to me to be not an unreasonable expectation on the part of people who are mindful of this Fourth Amendment.
I would agree.
Professor Klein, you talked about your reverence for the Fourth Amendment in the courses you teach. Why would asking the agencies to go for a warrant in 100 cases be a hardship?
Thank you, Senator, and I appreciate the question, and I, of course, appreciate the concern for privacy and civil liberties. The issue is that in the most important cases, where the query actually is exceptionally valuable, you don't know that something is there. You don't know that there's this worrying connection until you run the query. That's why these queries can potentially be so valuable, because something may seem like this level of a priority, but when you find that the person previously spoke to an al-Qaeda terrorist overseas or a Chinese intelligence officer overseas, all of a sudden the case takes on a new complexion, a new urgency, and it goes to this level of priority. Just like if before 9/11 the investigators had realized that Khalid al-Mihdhar had a multiple entry visa to come to the United States and actually had entered the United States, that search would have gone to a code red immediately. We need to find these analytically explosive but unknown facts by running these queries. And so by definition, you won't know to go to get a court order unless you realize that the information is there.
And you believe current rules don't allow that to happen?
Well, current rules don't require a court order, Senator. I actually share Mr. Baker's concern that current rules may be allowing too few queries. The Fort Hood Commission said we need to have federated query tools to enable FBI agents to discover analytically significant information in FBI holdings. I understand that we.
Your response?
It never ceases to amaze me when I hear the argument that the government shouldn't have to get a warrant because they don't have anything approaching probable cause. The fact that the government is conducting thousands of searches of Americans' private communications every year on just a hunch is exactly why we need a warrant requirement. The purpose of warrants is to prohibit exactly those kinds of fishing expeditions. That is the balance that the framers struck.
Thank you. Thank you, Mr. Chairman.
Thank you all. Thank you all for being here. I think we can all agree 702 reauthorization is important. Obviously, privacy concerns of American citizens are important. But I think initially we're conflating a couple of things. Unfortunately, historically, with the FBI having both law enforcement authorities and intelligence authorities, those are two separate things. Would you agree, Mr. Baker, that basically law enforcement looks retrospectively to see if someone has committed a crime, and obviously it's a little easier to go to a judge and say, here's probable cause to show why we need this warrant. Intelligence gathering is different because it's prospective. For example, in 9/11, it was largely seen as a failure of intelligence. But can you talk about the difference between law enforcement and intelligence gathering and why 702 is important to the latter?
So yeah, I was inculcated into this early on in my career when somebody said to me, well, the difference between intelligence and law enforcement is that intelligence finds the suspects and wants to string them along, and the law enforcement finds them and wants to string them up. The purpose of intelligence gathering is to get access and use it for as long as possible to find out what's happening. And for law enforcement, the purpose is to end in a courtroom with a conviction. But the fact is that terrorism, espionage, all of the things that we care about for intelligence purposes are also violations of our criminal law. So you cannot separate them easily into those two categories. Our effort to do that produced the tragedy of the wall. And the notion that we should separate intelligence from law enforcement by saying, oh, you need a separate warrant if you've got a separate interest in getting access to information we already collected for intelligence purposes is the same kind of mistake. We shouldn't make that mistake with something as important as things like terrorism or espionage.
Well, there can be, can there not, Mr. Klein, be a reason for using FISA 702 to query a person overseas, a non-American citizen that isn't law enforcement related, that's strictly related to getting intelligence to help supply the dots we need in order to understand what's going on? Would you agree with that?
Yes, absolutely, Senator. The targets under 702 are non-Americans overseas who are likely to possess foreign intelligence information. And then we have FBI agents conducting national security investigations, whether criminal or intelligence. As Mr. Baker said, they're commingled here in the United States. And if one of those people in the United States is connected to a priority foreign intelligence target, that is potentially very concerning, very alarming. We may need to act on that very quickly to prevent a terrorist attack or some other catastrophe.
Well, I've heard people talk about the importance of a warrant, but they tend to conflate Title I of Section 702, which was used against Carter Page, and I think we can all agree that much of the public skepticism around FISA was related to the disgraceful use of 702 Title I to investigate an American citizen without cause. But we're talking about a different section of FISA, Section Title VII. So non-U.S. persons outside the U.S. and currently the FBI can query lawfully collected intelligence without securing a warrant to look at the database or the file cabinet, as you point out, that's sitting there in their office. So how would you go about getting, if in a case where it's not a criminal investigation, but it's strictly an intelligence gathering matter, how would you get a search warrant? What would you show a judge about probable cause that a crime has been committed in order to be able to query that lawfully collected intelligence? I just don't, it doesn't seem like it fits.
Yes, Senator, and another conundrum is that you often don't know that there is an urgent need to take action until you run the query. The agent doesn't have access to that information yet, and so checking your databases to see whether there is a very dangerous, alarming connection is a prudent, early step in an investigation. If you require probable cause, you take that off the table altogether because you typically don't have probable cause right at the outset of an investigation.
My time's expired.
Thank you. I previously served on the Intel Committee, so I do appreciate the value of Section 702 as a tool in protecting our national interest security. But I have never voted in favor of authorizing or reauthorizing Section 702 because of civil liberties concerns, especially regarding U.S. persons inquiries. And as noted, these inquiries can be in the thousands, and U.S. persons' communications can be opened up in that way. So the last time we considered this issue of the privacy rights of U.S. citizens, Senator Durbin and Lee offered what, to my mind, was a compelling compromise. And you can conduct, this was a compromise, you can conduct U.S. person inquiries and see if there are results. But if you want to view the contents of those results, you need a warrant. So you can look at the outside of an envelope, but if you're going to open up the envelope and look inside, you need a warrant. So there was previously the assertion that Fourth Amendment did not apply to these FISA queries, et cetera, but that blanket assertion is no longer the case because there is now the Eastern District of New York case. And so that leads me to my question of Ms. Goiten. Am I pronouncing your name?
That's right, Goiten.
Goiten. So I think that you share my concern that there should not be this blanket Fourth Amendment concern because of this decision. So can you explain what the district court concluded in the Eastern District of New York case?
Sure, and it's not just a single district court. It was actually a unanimous three-judge panel of the Second Circuit that held that a query is a separate Fourth Amendment event from the original collection. The government had made the argument there are no restrictions on lawfully collected information. The FISA court had accepted that. A handful of district courts, without a whole lot of analysis, sort of went with the FISA court's assessment. What the Second Circuit said is, no, there is often a restriction or restrictions that the Fourth Amendment place on lawfully collected property or information. One example was the Supreme Court's decision in Riley in 2014, when the Supreme Court held that a lawfully seized cell phone could not be searched. The contents couldn't be searched. It was initially seized without a warrant. It was a search incident to arrest. And that in order to actually search the contents, the government had to go back and get a warrant because the search was a separate and greater privacy intrusion under a different justification than the initial search. It did not base its decision on the fact that this was property that still belonged to the person who owned the cell phone. Similarly, when the government gets a warrant to seize a laptop to search for evidence of tax fraud, it's lawfully in possession of the laptop. It can only search for evidence of tax fraud. If it wants to search for evidence of another crime, it has to go back to the court and get another warrant. On remand, the way the district court put it was a search that relies on an initial warrant or exception to the warrant requirement is limited by its original justification, and to intrude further on lawfully acquired items requires new and independent approval. And that is certainly the case in Section 702. Very quickly, Adam Klein has said that this was all about property. And whose property, whether the information is the property of the person or the government. The Supreme Court did away with property-based distinctions in 1967.
Excuse me, I am running out of time.
Yes.
Every time the issue of requiring search warrants comes up, the Justice Department says everything would come to a screeching halt. Do you agree with that kind of a broad, we can't do it? It would just stymie their efforts to protect our country?
Not at all. There's no case in terms of how much of a burden it would be. As we discussed before, we're talking about, if the government's numbers are correct, we're talking about maybe a couple of hundred of warrants a year. And in terms of national security, as I mentioned before, there's been, I have much more to say about this, but I know we're running out of time. The Privacy and Civil Liberties Board looked at the evidence and said, among the few backdoor searches that were useful, these searches could have taken place even if a warrant with certain exceptions were required.
Thank you very much.
Senator Lee.
Time is up.
Thank you, Mr. Chairman. Thanks to each of you for being here today. This is an important topic, one that I've focused a lot on for the entirety of the 15 years I've served in the Senate and on the Senate Judiciary Committee. Each time we bring up this issue or another issue related to it, we tend to hear a very similar set of arguments. The arguments go something like this. Yes, there have been problems in the past. Yes, there have been abuses of FISA 702. But you need not worry, because we now have procedures in place, administrative procedures that will fix the problem once and for all. We now have to have even more layers of administrative approval within the agencies charged with administering this framework, and so you need not worry. What you ought to be worried about is another 9/11. What you ought to be worried about is that we are all going to die unless the U.S. government has the ability to collect content of private communications involving U.S. citizens without a warrant. I find this rather troubling, because that's not what the Constitution sets up. The founders didn't design a system in which liberty and the protection thereof depends on compliance with manuals. Now, in Riley versus California, Chief Justice Roberts, writing for a unanimous court, explained that while it's probably a good idea, as he put it, for the government to develop search and seizure protocols, quote, the founders did not fight a revolution to gain the right to government agency protocols. Ms. Goiten, I'd like to start with you. Do you agree that without a probable cause warrant, a probable cause requirement, with a warrant being issued by a co-equal branch of government, 702 lacks the structural checks and balances that are necessary and that the Founding Fathers deemed necessary in order to restrain executive power in this area?
I would agree with that. I would agree as a legal matter and a practical matter. As a legal matter, as I was starting to say, the Supreme Court has held that the Fourth Amendment applies not when there's been an intrusion on property, but when there's been an intrusion on a reasonable expectation of privacy. And Americans have a reasonable expectation of privacy in their communications with others, including foreigners. If these Americans voluntarily gave their communications to the government, they would waive that interest. That's the third-party doctrine. That's not what has happened here. And there have been cases in which the government obtained information and returned the actual property, the laptop, to the person who owned it, mirrored the contents, kept those contents on its own property, its own hard drives, its own disks. And the court in the Second Circuit in Ganias still held that the Fourth Amendment limited the government's ability to keep and access that data.
Yeah, that is a great point. And if we look back the history of the Fourth Amendment and to the centuries of English antecedents to the Fourth Amendment, preceding the Fourth Amendment's adoption, what we find is not a situation in which it was adequate that those who were executing, I don't know, writs of assistance or general warrants under English law, those administrative layers of approval and compliance manuals that I'm sure they had, didn't do the job either. And that's why we have a warrant requirement. That's why it's so important. Now, Mr. Baker, in your written testimony, you make an analogy to driver's licenses and to the ability to search DMV databases for driver's licenses. I'm not sure that that one helps you much, though. I'm not sure that helps the argument here. I mean, first of all, you're dealing there with information that is lawfully obtained by state governments on American citizens. They become sort of matters of public record that somebody has a driver's license. Whereas with FISA 702, you're dealing with the contents private conversations and private conversations directed at foreign intelligence. So isn't that the first point where your analogy breaks down?
No, I don't think so. The purpose of 702 is to collect the communications using U.S. infrastructure of foreign targets. Of course, some of those foreign targets are going to be talking to Americans from time to time, and you can't collect their communications without also getting the Americans who are talking to them. But you have lawful authority to gather those communications. And once gathered, you can use them for other purposes that are related to that. And
well, sure. But if you get in there, I mean, it becomes analogous at some point to an officer who figures out a way to get inside of a home and then exploits that, or figures out a way to initiate a Terry stop and then extends that visit longer than it was intended to cover at the outset. One more point before my time expires. Mr. Klein, a moment ago you made some references to 9/11 and to the fact that, lamenting what happened then. Now, last I checked, 9/11 was carried out entirely by foreign nationals, not by American citizens. How does that justify warrantless surveillance of private communications involving U.S. persons on U.S. soil?
Well, U.S. persons also includes lawful permanent residents, so under the statute, that term
Fair
includes
enough.
lawful.
Fair enough. These were not LPRs, but regardless, go ahead.
Sure, and it's possible that Americans are sometimes, unfortunately, suborned, recruited by foreign terrorist groups as well, sometimes unwittingly, are used by foreign terrorist organizations. In those cases, a U.S. person query can help warn that person, redirect them away from being recruited. In fact, a significant proportion of the queries that are run actually relate to victims of things like cyber attacks or unwitting recruitment by foreign intelligence services.
But that is not what those of us who are concerned about 702 worry about. That is not our principal focus. Our focus is when somebody is going after information, private communications of U.S. persons, there ought to be a warrant requirement.
Senator Welch.
Thank you very much. Thank you. Sometimes incidentally of American citizens. And there's two issues always involved with this, in addition to the trade-off between national security and privacy rights. One is whatever the administration in charge is, we have to have some trust that they're going to operate within the proper constraints. But the second is we've created some constraints which are intended to have an aggressive and assertive advocacy on behalf of the privacy side of the equation. And one of those was the Privacy and Civil Liberties Oversight Board, which, as you know, is an intelligence watchdog that's charged with monitoring government compliance with the procedural safeguards on the surveillance activities. That was terminated, as you know, by President Trump. And in May of 2025, shortly after Mr. Patel became FBI director, he shuttered the Office of Internal Auditing, which was, you know, was the unit responsible for overseeing the government's compliance with their surveillance rules. Ms. Goiten, how does that help create public confidence that when 702 is used, it is going to be for the purpose of national security protection, and it's being done in a way that's consistent with privacy rights that all Americans enjoy?
It's a real concern. As I was saying before, we don't have any data on implementation of statutory safeguards in 2025. The fact that the Privacy and Civil Liberties Oversight Board was gutted, the fact that the Office of Internal Audits was disbanded, does not give a lot of confidence that the oversight provisions of RISA, for example, are being robustly enforced.
You know, Mr. Baker, I appreciate the work you've done on 702 over the course of your career, but as a strong proponent of 702 for the reasons you've outlined, are you a proponent of getting rid of PCLOB and also the internal function that was disbanded by Mr. Patel?
No, I'm a believer that proper bureaucratic incentives are likely to be a better protection of civil liberties than a warrant requirement. We had a warrant requirement on FISA when Carter Page was inappropriately surveilled, and 4 different judges on the FISA court said, yeah, fine. So a warrant requirement doesn't necessarily protect civil liberties, and good bureaucratic controls can.
So in your view, was the PCLOB something that was helpful to protect privacy rights?
They wrote an excellent report before they lost their majority that is really the best piece of work on 702 that's been done.
Well, that's an incredible endorsement, Mr. Chairman. And did it make sense for Mr. Patel to shutter the Office of Internal Auditing to achieve your goal of a good 702?
I don't know the details of that, but I would support any mechanism that does a careful job of evaluating people's justifications for the searches that they do.
Well, thank you, because it seems like we're taking a step backwards. I mean, I wrestle with this question of the warrant requirement because there is incidental collection of Americans. And I know many of my colleagues across the aisle are strong proponents of protecting civil liberties. So when you have a couple of offices that are strong in the moment advocates for the balance, it's disappointing to me that those would be disbanded. Thank you. I yield back.
Thank you, Mr. Chairman. And I want to probably just use my time to throw this question out for the 3 of you, which is, do each one of you, and we can just start down the row, believe that the reforms that the chairman has offered, do they adequately address the abuses that we saw, say, with the Carter Page or Michael Flynn incident? Because I do think that there's a broad concern that this abuse, it happened and it could happen again. And I think at least somebody who wants to be reform-minded, how do you view that? And if you think it's inadequate, what else would you propose that we do?
So I do believe that more oversight of the FISA court is appropriate. They haven't gotten their share, and they have been responsive to the people who they think are watching them most closely, which tends to be civil liberties advocates. Instead, having the Congress present, and certainly having Congress oversee the list of amici makes a lot of sense as a way of demonstrating that the FISA court needs to take account of the people who wrote the laws as well as the people who are lobbying on them.
Is there anything else that you would do to deal with the abuse that you would propose?
I think we've run to the end of legislative reforms in this area. That certainly it would make sense to ask the intelligence community to create a mechanism by which you could determine whether you could do a search to determine whether somebody's in the database and for what investigation, without having this query concern arise. If we could get to the point where only 2% of the people who have been looked at have to be the subject of a warrant, it would be much better. But I don't think at this point that the IT systems will support that kind of a search.
Ms. Goiten.
If we're talking just about improving the functioning of the FISA court for the moment, then I would say that that RISA combined with a couple of the chairman's proposals take some steps in a good direction. They fall short of the full set of reforms to the FISA court that were proposed in the Lee-Leahy amendment in 2020, which became the Lee-Welch amendment in 2024. That passed in 2020 in the Senate by a vote of 77 to 19. There's no reason not to embrace that full suite of reforms In addition, RISA took two major steps backward when it came to the role of amici in the FISA court and weakened the role of amici. First, it limited amici to only addressing issues identified by the FISA court. The primary value of amici really is to identify issues that the FISA court hasn't thought of. So this would have crippled amici, for example, in the Carter-Page scenario, where the court hadn't identified any issues with the materials. RISA also required amici to have experience in intelligence collection. That's going to weight the selection of amici heavily towards former government officials who may come in with institutional bias. That government perspective is already represented before the FISA court. So those changes should be repealed.
Okay. So these reforms plus the reforms that the Lee.
A couple of those reforms. I wouldn't support having Congress, having the amici chosen by Congress. I don't think that will make things less political. I think it will make things more political, unfortunately.
Mr. Klein.
Thank you, Senator, and thank you for also mentioning the Flynn leaks, which is something I wrote about almost 10 years ago when it happened, and which was a very disturbing example of signals intelligence being leaked to politically target an American citizen, something that's completely unacceptable. RISA made many changes, which I think will help get potential political influences out of the FISA process. No more political opposition research, no more unsourced press reports, having lawyers review U.S. person applications with closer scrutiny, and many other things that are listed in my written testimony. Those need time to run, but I think they will run more effectively if Congress is able to get in there and see how the process is working and provide that additional congressional oversight and scrutiny. So that's why I support the additional reforms in this committee's bill.
What do you do? I mean, because I think in the Steele dossier was omitted from, so the idea that you would sort of take the political opposition research out of it. The problem is that was hidden. In my recollection, it was hidden from the court in an effort to pursue this, right?
That's right, and the bill from 2 years ago requires the government to explicitly call out if it's using that kind of information and not try to bury it or hide it.
Okay, thank you, Mr. Chairman.
Yeah, Senator Hawley.
Thank you very much, Mr. Chairman. Thanks to the witnesses for being here. Mr. Klein, if I could just start with you back to the 702 context. You said a moment ago that 702 cannot be used to target Americans, correct? But that's cold comfort, isn't it, to the 278,000 people or tens of thousands of people who were the subject of 278,000 improper searches, United States persons that we're talking about in 2022 alone. I mean, sure, the statute doesn't permit them to be targeted, but when they have their personal information directly queried in an improper search, I mean, what's the difference?
Yeah, thank you, Senator. And obviously, if there's noncompliance with the rules, that's a big problem. And if there's any suggestion that things are being done for political purposes or other improper motives, that's a big problem. It's something I've written about many times. I think there is some comfort for Americans, even if they're queried, from the fact that foreign intelligence targets overseas are the people on whom this collection is based.
Why? Why would that be?
That is a big.
Why would that make me feel any better? As, by the way, as someone who's had his cell phone tapped improperly by the United States government, by the way, why would I feel any better if I'm told that, oh, the U.S. government improperly queried your personal information, and not in this case just your location or something else, your personal communications. The government looked at those, targeted them, you can use whatever verb you want, found them out. But don't worry, they weren't going after you in the first instance, they just happened to have all your stuff, and so then they looked into it because there are no effective constraints on them. I mean, why is that a good thing? Shouldn't we do something about that?
I'll say I think members of Congress do have a heightened reason for concern, a heightened expectation of safeguards in this area. Members of Congress have every right and every reason to talk to foreign officials. And of course, the executive
What about
branch
journalists? What about normal Americans who is somebody who's got a family member who lives overseas? I don't care who the person is. My point is, when you've got in a single year 278,000 improper queries, it seems to me it makes no difference to the Americans whose data was improperly searched to say, well, but it's really okay because you weren't targeted. Yeah, all your stuff was read, all your private stuff, but don't worry, you weren't targeted. I mean, apparently you were effectively targeted.
Yeah, Senator, I think we have to remember this data is being collected on foreign intelligence targets overseas. It's not like going to the phone company and checking all the phone records that are there.
But it sweeps in quite a bit of American data, right? I mean, the case, the Hasbadrami court noted that in 2011, now that's ancient history now, 2011 alone, this swept in something like 250 million emails in 2011. Who knows what that is today? We're talking about massive amounts of data that 702 sweeps. It's like a dragnet, huge amounts of data. Which leads me to the question, why shouldn't we treat a query of an American person in this database as a separate Fourth Amendment event?
Yes, Senator, I just want to note that the second narrowing function is the FBI is only getting 3% of the overall target set from this. So it's a subset of a subset that's being checked, and there, in most cases, there's nothing there.
Why shouldn't there be? Why shouldn't we treat? Why isn't it logical, as the court said in Hasbadrami, the Second Circuit unanimously? Why shouldn't we treat the querying of U.S. persons out of this dragnet database? Why shouldn't we treat that as a separate Fourth Amendment event requiring some additional process? Maybe a warrant, as Senator Lee has proposed, maybe some other process, but why shouldn't we say, you know, actually, yes, when you go to this massive database and ask about a U.S. person, that's a Fourth Amendment event that requires some process, some scrutiny.
Yes, and so there are two answers to that. One is a legal answer, and we've covered that a lot, but in short, we don't require the FBI agent to get a warrant before going to check the filing cabinet.
Yeah, but this is totally analogous to that, as the Hasbadrami court said, right?
Sensitive records.
And as indeed the U.S. Supreme Court said in Riley. I mean, this is a completely analogous to saying that you have a piece of information down in a locker somewhere that you got pursuant to probable cause and indeed a warrant for a particular case. Here you have a massive dragnet of information. You just told me a second ago that you couldn't target the American citizens. So none of this information with the American citizens has received any process whatsoever. But now the FBI or the NSA, whomever, can go and query this database for the first time and get information on U.S. citizens, particularly for the first time, and you're telling me that that's not a separate Fourth Amendment event?
Well, Senator, I don't know what the first time. And when this information comes across the transom, there's an analyst, let's say at NSA, who's monitoring that target, or at the FBI, if it's one of their investigations, and they can read the whole thing.
It's the first time that the U.S. person has been the subject of inquiry, though. It has to be under the statute, because you told me a second ago you can't target a U.S. person.
Right.
It's got to be purely incidental. And the statute also says you can't target a foreign person for the purpose of getting information on a U.S. person through the back door. So it therefore follows that when you go to query the database, later query a U.S. person in the database, that's the first time the U.S. person is the subject of the inquiry. And my question to you is, that looks an awful lot like a search and seizure for a Fourth Amendment purposes. Why shouldn't we say, yeah, okay, that's a Fourth Amendment event. We need some additional process around that.
Yeah, and Senator, I think the government has already collected this information. In many cases, an analyst may have sat there and read the email. To me, it seems passing strange to say that someone has a reasonable expectation of privacy still in something that an intelligence analyst has sat there and read as it came across in their collection stream.
Well, it just seems to me you can't have it both ways. You can't say that there's no targeting of U.S. persons that's forbidden under the statute, but then when they do want to actually target a U.S. person, they don't need any process for it. You're saying on the one hand, no process needed on the front end, no process needed on the back end. I just think, Mr. Chairman, this is an extremely, extremely important issue. 278,000 improper queries of Americans in 1 year alone. The idea that we would renew 702 without some sort of reforms to protect U.S. citizens, I think is just totally irresponsible.
Senator Schiff.
Thank you, Mr. Chairman. I want to ask you about a possible means in which law enforcement or intelligence agencies might circumvent the requirements of the Fourth Amendment by acquiring information from third-party data brokers. That is, the Supreme Court in 2018 held that if you're going to seek geolocation information, that a warrant is necessary to compel a cell phone company, for example, to provide that data. In the Electronic Communications Privacy Act, we prohibited the disclosing or selling of customer data to government agencies, but that doesn't cover third-party data brokers. Is there any reason we should allow the government to get information by buying it that they can't get without a warrant otherwise? Be interested in your thoughts, whether you think that should be prohibited or whether there's some argument to be made for continuing to allow that practice.
Thank you very much for the question. I think this is a vital issue. I think, some people may not see the connection to Section 702. It's very much there. Section 702 is part of an ecosystem of often overlapping surveillance authorities. And when one avenue is closed off, the government can often turn to another or exploit gaps in that network to conduct surveillance with no statutory authority at all. And the gap I'm most worried about is this data broker loophole. Federal agencies are buying their way around constitutional and statutory requirements on a routine basis. You mentioned that the Supreme Court in Carpenter held that police need a warrant in order to collect a week's worth of cell phone location data. And yet a veritable alphabet soup of federal agencies, including the Department of Defense, DEA, FBI, IRS, ICE, Customs and Border Protection, are all buying up American cell phone location information in massive amounts without any process whatsoever, not a warrant, not a court order, not even a subpoena. And the way they're doing this is because apparently government lawyers have taken the position that even though a warrant is required to compel production of the data, a warrant is not required when the government merely incentivizes production by writing a big check. So that leaves us with statutory protections. And as you mentioned, the Electronic Communications Privacy Act is woefully outdated. It covers telephone companies and internet companies. They cannot sell data, sell the kinds of data we're talking about to the government. But because this old law doesn't cover...
No, thank you. I appreciate your answer.
I could go on a long time
one
about
other
this.
question while I have time remaining on a different topic, and that is, it always seemed compelling to me when we've had this debate in the past that you should be able to do a search, a query, involving a potential target of a ransomware attack or a location that might be the subject of a foreign terrorist plot or bombing plot. Have we outlawed being able to do those kind of searches by getting rid of about searches, or in order to search a descriptor of a place or a potential victim, would that be caught up in a warrant requirement? And under what circumstances would that be problematic? That is, there are other cases where you have a known potential victim and you still require a warrant. What makes this circumstance different? So if any of you can answer that question.
Yeah, I'd love to take a shot at that. I mean, the reality is that there is no victim exception to the Fourth Amendment. The need to protect victims is hardly unique to the Section 702 context. Law enforcement officials in this country are charged with protecting the public, and they do it every day, and they manage to do it while respecting the Fourth Amendment, including at times by obtaining the consent and cooperation of victims, as well as invoking emergency exceptions to the warrant requirement. So the proposals for a warrant requirement for backdoor searches would all include exigency exceptions. That would include exceptions for victims' consent, and the leading proposals also include an exception for certain cybersecurity-related queries for the reasons you say.
You know, I would welcome it if the chairman will allow. I'd love to hear any counter argument if you'd care to make it. What I'm most particularly interested in is, would it be appropriate to search for a potential victim in a case where you may not have probable cause, where you may not be able to show the particularity you would need for a warrant? Is it just the victim's right alone? That is, if there's going to be a bomb threat against the premises, the community has an interest in not seeing that succeed, not just the venue. Should the owner of the venue, let's say some institution, decide not to give that approval, does the government have an interest nevertheless in preventing that terrorist attack from going forward? That should override it.
If I could jump in on that, yeah, I think the point of your question is that we shouldn't borrow some of the less functional aspects of existing Fourth Amendment law in this context where we are writing an entire set of procedures for the government that are designed to protect particular aspects of privacy. But you don't want to have a situation in which people say, oh, you put in an address, that's really a disguised search of the person who lives there or people who go there, and you needed a warrant for that. Or you needed a warrant for a victim. Maybe there isn't under the Fourth Amendment but an exception, but it makes sense to say that the government should move faster and have fewer constraints when they can demonstrate that they're looking for a victim and it's time sensitive.
Senator Coons.
Thank you very much, Chairman Grassley, for holding this hearing today. Section 702 implicates some very foundational American liberties, and this is exactly the sort of oversight hearing and pre-action hearing that this committee ought to be having. I really appreciate you dedicating this time. And to our witnesses, thank you for being here. Section 702, as we all know, is a critical tool in the fight to keep Americans safe. Information collected through 702 has disrupted terrorist attacks on American soil, exposed foreign ransomware attacks on U.S. infrastructure, prevented weapons of mass destruction from reaching those who would use it to do harm. But Section 702 does not and should not give the government carte blanche to collect and search the communications of Americans in any way that it chooses. So I remain deeply concerned about the breadth of this program and its potential for infringement on Americans' constitutional rights. I voted against the reauthorizations of Section 702 in 2012 and 2018 because, in my view, at the time, those bills did not do enough to protect Americans' privacy. However, in 2024, I voted to approve a short 2-year extension because I was convinced that the reforms in that bill, like robust accountability procedures at the FBI and opening the doors of the FISA court to congressional oversight, could make a big difference. And today, I had hoped to hear from witnesses about whether those reforms have been appropriately implemented and whether they've been effective, but I can't ask those questions of officials from the government who are actually implementing those reforms because they're not here. No disrespect to the witnesses before me, but you're not the folks actually running these programs and implementing these reforms. We are 3 months from the expiration of Section 702, and the Trump administration, as best as I can discern, still has no official position on it. That is stunning. When then Chair Durbin of this committee held a hearing on Section 702 in June of 2023, a full year, nearly a full year before reauthorization, we heard directly from officials at the NSA, the CIA, ODNI, DOJ. I think it's unacceptable that with just 90 days, the administration doesn't know how it thinks about the program and has no one here to explain or defend it. If it's working well, why can't you tell us? Why can't you send someone to sit here and answer our questions about how the administration has reformed and improved this program to keep Americans safe without trampling constitutional rights? If you no longer support the program, why can't you tell us? Why can't you tell us what additional reforms we maybe should be considering to better protect privacy? Deciding whether or not to reauthorize 702 is a decision I take very seriously, and I owe it to my constituents, and I don't know right now which way I will ultimately vote because I don't know how this is being implemented. The Trump administration should be here to participate and answer some of the many excellent questions posed to this capable panel. Let me ask a few questions that are relevant, I believe, to your areas of practice and expertise. Ms. Goiten, could you just explain in plain terms how the expanded definition in RISA of Electronic Communication Service Provider, or ECSP, differs from the previous definition, the previous law,
Right.
and what new surveillance capabilities it may actually create for the federal government, and what would an appropriately narrow ECSP definition look like in your view?
Sure, thanks for the question. So this change in definition, as innocuous as it might seem, is what Senator Wyden referred to as one of the most dramatic and terrifying expansions of government surveillance authority in history. And unfortunately, he was not overstating the matter. The government conducts Section 702 with the compelled assistance of electronic communication service providers. Before RISA, these ECSPs, for short, were defined to include providers of actual communications services, such as Verizon and Gmail, that have direct access to Americans' communications. And the way it worked was that these companies would isolate and turn over the communications of the targets. RISA made a change, and the reason for that change was that in 2023, the FISA court ruled that FISA's definition of ECSP didn't include a particular type of provider, and that if the government wanted to include that provider, it would have to seek amendment of the law. That provider, we all found out through the New York Times, was a data center for cloud computing. This was confirmed by senators during floor debates. But even though it's now public knowledge, it remains officially classified, and so rather than actually seek an amendment to add data centers, the administration deliberately sought an amendment drafted in incredibly broad and vague terms to obscure the type of provider at issue. So under this new definition, the government can compel the assistance of any provider of any service, as long as that the provider or the employees or the custodians have access to equipment on which communications are routed or stored. Think about it. That's pretty much every business or organization in the country. There are some narrow exceptions in the definition, but almost every public-facing business organization provides a service, and they all have phones and computers. And because these types of businesses are not going to have the technical ability to isolate and turn over targets' communications, they may be forced to give the NSA direct access to their communications equipment with all of the purely domestic communications running through the equipment, and then the NSA is on the honor system to only pull out and retain the target's communications.
Do we know whether this has happened?
I certainly don't know whether it's happened. The Biden administration committed to only applying this definition to the type of provider at issue in that one case, and to reporting to Congress on its uses of the provision, not to make public reports. So that is one. If you haven't received these reports, I don't know that this administration is bound by the Biden administration's commitment, but that's a big problem, because the potential for abuse of giving the NSA direct access to the communications equipment of almost every business and organization in the country cannot be overstated.
I recall this debate. Mr. Klein, if you could briefly, do you think we need to revise this definition and narrow it?
Under the USA Freedom Act, and as elaborated by subsequent laws Congress has passed, the intelligence community is supposed to declassify novel or significant interpretations of law that come out of the FISA court. The Congress also should be receiving unredacted versions of those important FISA court opinions. So if there's a significant expansion in that term beyond what's expected, you all should know about it. Eventually the public should find out. But as for data centers, if a Russian general is putting his stuff on a data center in the United States, and we can get that to protect the American people and our allies, I think we should do it.
This ends our hearing.
Thank you.
I want to thank all of you who worked hard to prepare for this and be here to do it. And I also thank my colleagues. I look forward to having my colleagues give me the benefit of your continued thoughts concerning potential reforms. And particularly, I'd like opinion on my proposals. Written questions can be submitted for the record 1 week from today. I'll ask the witnesses to answer and return questions to the committee within 2 weeks after you receive those questions. Thank you very much, and meeting adjourned.